Morning students, welcome to the crash course of Ekcel Academy. If you have already not registered for the crash course, I would suggest please do register. All you have to do is just visit the link in the description. You can see the URL on the screen as well, that is www.ekcelacademy.com, EKCELACADEMY. Now you may ask what exactly is the benefit of signing up on the website. We are anyway getting the free crash course on YouTube itself. Of course you are getting, but it's just the crash course, meaning what we are essentially doing is we are trying to cover mostly the important topics in as little time as possible, because the exams are nearing. We may not be able to cover everything in the class, that is the live class which we are conducting now on YouTube. So if at all you want the detailed recorded classes which are sorted chapter wise, topic wise, then I would suggest go to the website in the description, register there. Of course you don't have to pay for anything. Then you can access the classes. Not only classes, there are quizzes, MCQs, then you can take up mock tests as well, and there are notes available for almost all the subjects, so make use of that. So anyway, it's you don't have to pay anything for that. So yeah, that's about it. So today we have a new topic that is for the first time in the crash course, that is legal aptitude. We already covered one part of this subject, that is logical reasoning to some extent. Now we'll be looking at legal aptitude today and tomorrow. As you can see on the screen, this will be for 50 marks, and that 50 is split between legal aptitude and logical reasoning, 25 each. Let us quickly go through the syllabus once. We have Indian Constitution, we have preamble, citizenship, rights, duties, etc. Then we have elements of general laws, one of the most important chapters, one of the most biggest chapters as well in the legal aptitude subject. That is, we have law of contract. There we have two subdivisions. One subdivision would be that of law of contract, the other one being law of torts. So that is there. Then we have elements of company secretaries legislation, that is the ICSI Act. Then we have the elements of company law, brief introduction to one of the major subjects in the entire course. Then we have legal reasoning, kind of a question and answer session wherein we try to understand few legal terminologies as well as go through few case laws. So that's about it. Though it's 5 chapters, chapter number 2 and even chapter 1, that is Constitution, is also fairly lengthy. So what we'll do is I will start with chapter 2, because as I said, it's one of the biggest chapters and one of the interesting ones as well, that is law of contract. Let's start with that today. Okay, here we are. Before we even proceed further, let me ask you a question. Have you ever entered into a contract? Most of you might think no, we haven't entered, because you will be thinking of formal contracts wherein there is a contract drawn up and written contract, of course, and you are one of the parties to such a written contract, and you may or may not have actually entered such a contract. Not everyone at your age would have entered into such a formal contract. But forget about that for a second. Apart from that, we have so many informal contracts as well, which you would have definitely entered. So when you pay fees in your name to the college, you are of course entering into a contract wherein you are telling the college, I am paying you the fees, now you deliver the lessons or you teach me. So when you enter into a restaurant, you won't tell the restaurant owner that you serve me food of my choice and I will make you the payment later on. The moment you enter and place an order for the food, it is assumed that you will end up paying for the food. Or when you go to a petrol bunk and ask the person to fill the fuel, it is already assumed that once he does his work, you will make the payment. So there is no explicit agreement here in any of those examples which I mentioned just now, but still there is an implied contract between the person who, like for example in case of restaurant, between restaurant owner and you. In case of petrol bunk, the person who fills the fuel, and you, the receiver of the service and the renderer of the service. Or if you are buying something, then the person who is selling and the person who is buying. We have been entering such contracts day in and day out, just that we are not aware that we are already entering to such contracts. So whenever we think of contract, we always think of formal contracts. Of course, they are the perfect or the best examples of contract, but it doesn't necessarily mean that only they are considered as contracts. So everything which you have already entered into so far is also a contract, just that there is no written agreement. So let us see what exactly we have in store here. So what do they say? Introduction. A contract is an agreement enforceable at law. Of course, this is the most important part here, enforceability. So if it is just an agreement which is not at all enforceable, then what is the point of even having an agreement? An agreement is something which should be enforceable. Otherwise, the agreement will not have value. Once it becomes enforceable, it becomes a contract. That's it. Made between two or more persons. Of course, we cannot have a contract with ourselves, by which rights are acquired by one or more to acts or forbearances on the part of the other or others. That means one party does something, the other party may do something or may not do something, like someone might abstain from doing something. So that is what they mean by forbearance. So we'll see everything in detail later on. Okay. Megha Mondal says good morning. Good morning, Megha. Then a contract is an agreement creating and defining obligations between the parties. This is one of the most important point here. So as I mentioned earlier, when you visit a restaurant, you order the food. So now you are obligated, once the restaurant guy or the waiter gets the food to your table and you start having food, you are obligated to make the payment later on. You cannot say, I never told you that I will make the payment for food. So that is something which is created by contract. That is the obligation. Obligation is there on the part of everyone, or rather every party to the contract. 2, 3, how many ever parties are there. Now, which is this act which governs the Indian contract? So the contract is governed in, or at least contracts in India is governed by Indian Contract Act of 1872. A very old act, but an act which is near perfect. Let's see what exactly we have in store. Lays down general principles relating to formation, enforceability. How, first of all, how do we even create a contract, and how do we enforce such a contract? And then rules governing the provisions of an agreement and offer. So agreement is something like A says something and B says something else, and if they both are okay with the other's statement, then they say we are in agreement. So that is what agreement is all about. But once enforceability comes into picture, it becomes a contract. That's it. Now we have offer as well. So we'll look into all these in detail when we come to the specific topic. But in general, what we are trying to understand is what all the Indian Contract Act, or at least this chapter, covers. Let's move further. The law of contract constitutes the most important branch of mercantile or commercial law. Okay. Of course, it affects everybody in trade and commerce. But one of the unfortunate things is, when it comes to enforceability of contracts in India, we still are way behind the rest of the world. Okay. Anyway, they say the Indian Contract Act came into force on the first day of September 1872. Try to remember this fact. You never know, the institute might ask this type of questions as well, wherein you are supposed to memorize the day the contract came into force. So what does the preamble of the act say? To define and amend certain parts of the law relating to contract. So basically the English wanted to bring their law of contract to India, so they pretty much did the same. They also say the act is by no means exhaustive on the law of contract. That means not everything related to contract is covered, they say. Okay. It does not deal with all the branches of the law of contract. Thus, contracts relating to partnership, of course, we have specific acts for other things, like partnership is covered by Indian Partnership Act of 1932. So then we have sale of goods, negotiable instruments, insurance, etc., which are all dealt by separate acts. So if those type of agreements are not dealt anywhere else, it will anyway be automatically dealt in the Indian Contract Act. So now what do they say? They say majorly deals with the general principles and rules governing the contracts. Okay, fine. Let's not get into that. Let's straight away get into the contract definition itself. Now, the Indian Contract Act has defined contract in section 2H. Should you remember the section numbers? If you can, yes. If you think the institute might ask such questions like contract is defined under section 2H, 2A, 2B, 2C, they may give such options. Doubtful, but if you remember, it's there's no harm. If at all you have never remembered or never read the Contract Act earlier, now is not the time to remember. But if you have already read and understood the entire law, then you can obviously remember. Okay. Anyway, if you're reading this for the first time, then please forget about the section numbers and other things. Try to understand the concepts. So now let us see what is a contract. An agreement enforceable by law. That's all. Very simply defined. An agreement which is enforceable by law is nothing but a contract according to section 2H. Now, that means what? First of all, there must be an agreement. Without agreement, there is no enforceability. Once there is an agreement, then what should also be there for the thing to be considered as a contract? Enforceability. So both put together, we say it is a contract. Agreement plus enforceability. So okay, we understood that agreement is something which is necessary. Then what is this agreement? Let's read the definition of that too. They say, as per section 2E, agreement is every set of promises forming the consideration for each other. That's it. I promise something, you promise something. Whatever I promise is your consideration, that means your benefit, and whatever you promise is my benefit. So both put together, wherein I am exchanging something and you are exchanging something, both are anyway getting benefited mutually. So if that is the case, then we consider that as agreement. That's all. Okay. So basically it's promise and set of promises. Now, if you say what is it's a promise or set of promises, then the next obvious question would be, what is a promise? Let's read that too. According to section 2B of the Indian Contract Act, when the person to whom proposal is made. Okay. So now there is one more word, which is that proposal. Proposal is nothing but offer. You offer something to someone. That's it. When the person to whom proposal is made signifies his assent, meaning he says yes, or he may say no, signifies his assent, there too the proposal is said to be accepted. Meaning A tells B, I know you have a scooter, I wish to buy that scooter for maybe, let's say, 50,000 rupees. Who is telling this to whom? A is telling this to B. When the person to whom proposal is made, to whom the proposal is made now? To Mr. B. So who is making the proposal? A is making the proposal. Now who has to give his assent? Of course, B has to give his assent. The offer has been made, the proposal has been made, but B has not said yes or no. The moment B says yes or no, then the proposal is accepted. Proposal, when accepted by the other party to whom the proposal is made or the offer is made, then it becomes a promise. An agreement therefore comes into existence when one party makes a proposal and the other party signifies his assent thereto. Basically what they're trying to say is, you offer something to someone, they will think about it, then they may say yes or no. If they say yes, or if they agree, or if they give assent to such a proposal or an offer, then the agreement has come into effect, because it is nothing but a promise, and we know that every promise and every set of promises forming consideration for one another is nothing but an agreement. So in this example also, what is A telling B? I will pay you 50,000. So from the point of view of B, the consideration is rupees 50,000. From the point of view of A, the consideration is the scooter itself. So now there is exchange of consideration, mutual benefits. So one party gets cash, the other party gets the scooter. So forming consideration for one another. That is what they mean by that. Okay, let's see what exactly we have. They have given a diagram wherein they say agreement, plurality of persons. That means there must be two or more people. Otherwise, how can we agree with ourselves? How can we make promise to ourselves wherein we will be the one who will be enforcing and will be the one who will be getting the benefit of that promise as well, which makes no sense. So therefore, we need at least two people. Then there is this important concept called consensus ad idem. What is this consensus ad idem? It is a Latin phrase which means meeting of minds. Meeting of minds in the sense, if I am saying something to someone, they should also understand in the same sense in which I told them. If they understand in a different sense, then there is no meeting of minds. Let's say A is offering B his house for rupees 50 lakhs. A tells B, I am selling my house, or rather I am offering my house to anyone who pays rupees 50 lakhs. Now that's an offer which he has made to B, but he is telling B, I am ready to sell, but if you make the payment now, I will give it to you. Now B here is thinking about house 2, whereas A is thinking about house 1. A has different houses, many houses, but in B's mind it is house 2 which A is selling, but A knows that it is house 1 which he is selling. Finally, B gets 50 lakhs and tells him, okay, I like this house, that is house 2, please let's sign the contract. Then A realizes, oh, there is some problem here. There is no meeting of minds. There is no consensus ad idem. Consensus ad idem was absent here because A was thinking of something and B was thinking of something else. So if such a instance is, if that is the case in any agreement or contract, then we say there is no consensus ad idem. If there is no consensus ad idem, there is no contract. That is something which we have to understand. Next, obligation. We have already seen what is obligation. It is a duty of every party who enters into a contract. Let's see what they have to say. An obligation is the legal duty to do or abstain from doing. Either you do or you abstain from doing, because some contracts will have such clauses as well wherein they say you don't do this. If you don't do this, I will make you the payment. Let's say A is a producer, B is also a producer, film producer, and both they intend to release their movies on, let's say, April 14th. Then A tells B, see, I know you are also releasing the movie on 14th, but if I make you some payment, would you be ready to postpone the release of your movie? So in that case, B might agree or B might not. Let's assume for a second that B agrees. So A pays 1 crore to B to postpone the release of his movie so that there won't be any clash. So A wants all the audience at least for 2 weeks for his movie. So what B does is he will postpone his movie for so that his movie releases after 2 weeks. Let's say 28th. Now what is that B is doing? B is not doing anything. B is actually not doing anything, or he is abstaining from releasing his movie on the scheduled date, which was 14th. Now he won't release on 14th. For not doing something, he is getting some consideration. So this is also possible. It is not always to do something. Sometimes it will be to not to do something as well. A contractual obligation arises from a bargain between the parties to the agreement who are called the promiser and the promisee. The one who is promising to do something, promiser. The one to whom the promise is made, the promisee. Okay. Now, section 2b says that when the person to whom the proposal is, we already seen this. In broad sense, therefore, a contract is an exchange of promises by two or more persons, resulting in obligation. Okay, we already seen that. Now let us look at rights and obligations. Okay. Where parties have made a binding contract means both the parties are bound by the contract. Means if A has said something to B and B has agreed, then A is supposed to do something and B is also supposed to do something. So this is what they mean by binding contract. So they have created rights and obligations between themselves. We just now saw that. The contractual rights and obligations are correlative, meaning they're related. Okay. For example, A agrees with B to sell his car for rupees 10 lakhs. In this example, the following rights and obligations have been created. Let's see which are those. A's obligation is to deliver the car because A has the car. He has agreed to sell it to whom? B for rupees whatever it is, 10 lakhs, let's say. A has to deliver that car to B. That is his right or obligation. Sorry, duty or obligation. Now, B has a corresponding right to receive the car. If A has a duty to fulfill, that duty becomes B's or the other party's right. Now, B is also under obligation to pay what? 10 lakh rupees, because that is what the offer was by A and that is what B accepted. Now, A's obligation is to deliver the car, whereas B's obligation is to make the payment. So if it is B's obligation, obviously it will be A's right. So what will A get in return? He will get 10 lakh rupees in return. So here also we can see there is consideration, exchange between parties. That is one consideration which is flowing from one party to another is car. The other consideration which is flowing from B to A is nothing but the money. Now, we have seen few things, that is, we say agreements, if they are enforceable, then we say it is nothing but a contract. But are all agreements contracts? Are there agreements which are not at all considered contracts? Of course, yes, there are certain agreements which are definitely not considered contracts. We will see which are those. Agreements relating to social matters. Okay, what is this social matter? Now, I will give you an example. A tells B, who is his friend, why don't you come home for dinner tonight? Cancel all your plans, whatever plans you may have. So you please come home for dinner, maybe with your family. So now B cancels all his prior engagements, and at the appointed time, let's say 7 p.m., he ends up at A's door. But when he goes there, A's house is locked. Now, B is severely disappointed. He had to cancel all his plans. He took his family there. Now he doesn't know what to do because A's phone is not reachable. A's house is locked. After a few days, A calls up B and tells him due to some emergency, for some reason, he had to leave and go somewhere else. That's why he couldn't actually treat them for dinner and apologizes. Now B is very angry. He tells A, I'm going to sue you because we had an agreement wherein I would come to your place for dinner and you would serve me dinner. Not only me, but my entire family. But in this case, B cannot sue because it is a social agreement. The parties did not have any intention to create a legal binding. So it was just an offer and acceptance of hospitality. If that is the case, we say it is a social agreement. So therefore, there is no way the parties can sue upon one another. So that is one thing. Then we have domestic arrangements between husband and wife. If at all, husband and wife come to a domestic arrangement, and at some point of time, if they do not honor the domestic arrangement, we cannot tell either the husband or the wife, whoever it is, that there is a binding contract. Because between husband and wife, if there is a domestic arrangement, the court or the law will treat it not as a binding contract. So since it is treated not as a binding contract, then such an agreement will remain an agreement only and not a contract. In fact, this Balfour versus Balfour is a very famous case law. So it so happened that both the husband and wife, Balfours, and the British citizens were living in Sri Lanka. Back then it was known as Ceylon during the British occupation. For some reason they had to go back to UK for, I think, holiday, or maybe the treatment of wife was not feeling well. So they went back there. The wife got treated. But then husband realized if he takes her back to Ceylon or Sri Lanka, then she might fall sick again and there may not be anyone there in Sri Lanka to look after her. So he told her, do one thing, you stay back here. I will make sure I will send you some money every month, let's say 40 pounds every month, which was a huge sum of money back then. The wife agreed, thinking it's good for her as well because she won't be there in an unknown climate. She'll be here home in UK, where the climate of which is already familiar. So then the husband went back to Sri Lanka. So far so good. Okay, Megha has a question. Sir, please explain 1 or 2 points again. Can you pinpoint which exactly, Megha, so that I'll be able to explain that again? 1 or 2 means which one is that? Is it the example you are referring to? Just let me know, or just quote this sentence so that I can explain that again. Okay, let's move on. Where were we? Yeah. So then, where were we? Yeah, husband and wife. So now in this case, the husband went back to Sri Lanka. So far so good. He sent the money as well for some time. But after some time, he stopped sending money. Whatever was agreed between the husband and wife, that his husband would go back there, then send the money every month, he stopped after some time. Now what to do? The wife was angry. She realized that they had an agreement. The agreement was that he would send the money every month. Now he's not sending. She filed a case against him saying there was a contract between us wherein he would go back and send the money and I would be here in UK and get myself treated. But now he has stopped sending. Please advise or comment on this. So that she pleaded for a solution basically. But the court said this is a social arrangement rather between husband and wife, and there was no intention to create legal binding or legal contract between husband and wife. Therefore, we cannot consider this as an agreement, or rather agreement which is enforceable by law. Basically, the court said this is only a social arrangement or domestic agreement, not a contract. So therefore, not enforceable. So that is the famous Balfour and Balfour versus Balfour. In fact, similar cases as well. You can take a look at Jones versus Padavattan. So that is a very interesting case as well between mother and daughter. Jones versus Padavattan. Then there is one more similar case. I'm not able to recall the name. Millet versus Millet. I'm not so sure. Once I'm able to recall, I will let you know. So that is also between husband and wife, but wherein the court took an opposite view there in case of that particular case. So that is also interesting. Anyway, let's proceed further. 3 consequences follow from the above discussion. Let's see. To constitute a contract, the parties must intend to create legal relationship. This is the most important thing. There should be an intention. If there is no intention, there is no question of legal relationship at all. So the law of contract is the law of those agreements which create obligations, and those obligations have their source in agreement. So you may say obligations will be there, but those obligations should be there in the agreement itself, not elsewhere. The agreement is the genus of which there is the origin of which the contract is the species, and therefore all contracts are agreement, but all agreements are not contracts. That means this contract has arisen from agreement. Okay, therefore any agreement cannot be automatically considered as contract, but every contract can automatically be considered as agreement because contract is arising from this itself. But why is that all agreements are not contracts? Because in some cases, either as we just now saw, it might be a social arrangement, domestic arrangement, or it might be not enforceable at all. So if that is the case, then it will only remain as an agreement and not as a contract. Anyway, let's move on. Essential elements of a valid contract. So now that we know what is an agreement, what is a promise, what is a contract, what is social agreement, what is domestic arrangement, etc., etc., let us look at the essential elements. What all should be there for something to be considered as a valid contract? So here we have section 10 of the Indian Contract Act, very important section. This you may actually remember the section. It's easy to remember as well. Section 10, important one. Think of Sachin Tendulkar. His jersey was 10, one of the important players. So in section 10, one of the important sections in the Indian Contract Act provides that all agreements are contracts. All agreements are contracts if they are made by free consent of the parties. There should be free consent. They should not be coerced or something like that. Competent to contract, they should be eligible to enter into a contract. They should not be minors, etc. For a lawful consideration, the consideration should not be unlawful. The contract will not be or should not be for breaking someone's leg, then it would be unlawful consideration. And with a lawful object and are not hereby expressly declared to be void. Meaning, you have to fulfill certain things, and on top of that, this particular contract which you are entering into should not be expressly declared to be void. Meaning, there are certain contracts or agreements rather which are expressly declared void. Meaning, the government has said, or rather the law has said, if you enter into this contract or agreement, then in spite of it having all the other essential elements, it will still not be considered as a contract only because it has been expressly declared as void. So that is the thing. Anyway, let's move. The essential elements of a valid contract are, so what are those? An offer or proposal. Of course, without that there is no contract at all. So that is the initiation. Offer or proposal by one party. One party proposes, then acceptance of the offer by another party. So A proposes, B accepts, then resulting in an agreement. So this is what they say. Of course, we already seen this consensus added up. And an intention to create legal relations. Okay, we are joined by Sai Charan as well. Good morning, Sai Charan. So I hope you are able to understand. If you have any doubts, please do let me know. And of course, I've already mentioned this several times. If you are not attending the live session, or even if you are attending the live session, and if you have any doubts and you couldn't ask the doubt there during the live session and you want to still ask some questions, then go ahead and leave a comment below. Once the live session ends, I will definitely reply. Okay, let's move. So the intention to create legal relations, they say that we have already seen. Balfour versus Balfour, there was no intention. Then the agreement is supported by lawful consideration. Without lawful consideration, without lawful object, there is no contract. Lawful consideration. Then the parties to the contract are legally capable of contract. That means they should be competent. So we will see all this in detail. That's why I'm not getting into the detail. But think of this. If someone is of age 16 and if they wish to enter into a formal contract, they won't be able to enter because they are not competent. Genuine consent between parties, meaning someone should not be forced or threatened to enter into a contract, for instance. So if that is the case, then we say there is no consent, genuine consent. So this in Contract Act's language is referred to as free consent. The object and consideration of the contract is legal and not opposed to public policy. Whatever is your objective of the contract, that should be legal. Okay, again we can club this with consideration also. The terms of the contract are certain and not vague. So what is this certain? Certain means, I will give you an example. Let's say someone enters into a contract wherein they say, A tells B, let's assume, that I will buy some rice from you maybe sometime next week. Now, there is a contract. A intends to buy rice. A intends to buy rice next week from B. All this is certain, but how much quantity of rice and on which day exactly and for what price, nothing is mentioned. So in this case, this example, the contract is not certain, definitely vague. So if that is the case, then we cannot say section 10 elements have been fulfilled, but instead we say it fails to fulfill the section 10 elements and therefore not a contract. So we have to be careful if to check all the essentials. If even one of the essentials is not fulfilled, we say it is not a contract. It may at best be an agreement. That's it. The agreement is capable of being performed. That is, it is not impossible to being performed, of course. So impossibility of performance excuses the promisor from performing the contract. Again, the same thing has been repeated here. Let's not get into that. So what we'll do is we'll take a break of a couple of minutes and then we will continue. Welcome back. Let's look at the next major topic, that is offer or proposal and acceptance. One of the early steps in the formation of contract lies in arriving at an agreement between the contracting parties by means of offer and acceptance, they say. When one party, that is the offerer, makes a definite proposal to another party and the other party, that is the offeree, accepts it in its entirety, this is very important, and without any qualification, there is a meeting of minds of the parties and a contract comes into being. Okay, it looks like complex speak, but it is not so. So what is this thing? If I have to simplify this, there is an offerer who is making the offer, of course. Then there is another person who is offeree, to whom the offer is made. Let's say there is this guy A who is making the offer, so he is referred to as offerer. Then we have the other party B to whom the offer is made, so he is referred to as offeree. So we have an offerer and offering. So who is making the offer? A tells B, let's say, I am ready to sell my house to you for rupees 50 lakhs. Now B has to accept that, if at all he wishes to accept, in its entirety, means whatever A says or whatever A is offering, he has to accept without any conditions. That is what they are referring to as qualification. If there is any qualification attached by B later on while accepting, then it is nothing but rejection of A's original offer. If A tells B that I am ready to sell my house for 50 lakhs and B says I am ready to buy for 49 lakhs, will you agree for that amount? Then he has already rejected A's offer and is now making a fresh offer to A, in fact. So anyway, that is what they say. A proposal is also termed as offer. We have already seen that. What is proposal? Proposal and offer are one and the same in the eyes of Contract Act. Let's move on. Okay, they have defined proposal or offer as well, which is an important definition. Let's see what exactly the definition of proposal says. When one person signifies to another, obviously two people are required, his willingness to do or abstain from doing something with a view to obtaining the assent of that other. I will do this or I will not do this. Do you agree? If you agree, then that becomes a promise. But if I'm asking that question, then that becomes a proposal. So we have already seen who is offerer and who is offering. Let's not get into that. Excuse me. So now, rules governing offers. Like, there are certain things an offer must comply. So only then we can say that it is an actual offer. So which are those rules? An offer must be clear, definite, complete and final. Basically, it should not be vague. That's all. A promise to pay an increased price for a horse if it proves lucky to promiser is too vague and is not binding. Exactly. So you are telling someone, if this horse proves lucky to me today, I will pay you increased price. Okay. How do we know what is lucky now? And what is this increased price? Too vague, not clear, not complete, definitely not, final. So that is the thing. An offer must be communicated to the offeree. This is very important. If you don't communicate the offer itself, how will the offeree even know? A intends to sell his house to B for rupees 50 lakhs, but A never tells B. A thinks he has already told B, but B is not even aware of the offer. So in such a case, we say offer has not been communicated at all. An offer which is not communicated is not an offer at all. So therefore, this will not be considered as an offer. Next, the communication offer may be made by express words, oral or written, or it may be implied by the contract. So when we say communication, it need not always be in written or oral form. It can also be implied by the way you conduct yourself with the other party. So that is the thing. The communication of offer may be general or specific. Okay, this is very interesting. What they are trying to say is, to whom are you making the offer? Are you making the offer to a specific person, only to A, only to B, or only to a particular person C? Or is it an offer which is made to everyone? That is a general offer where anyone can accept. For example, there is an ad in the newspaper wherein they say, we are inviting applications from people for the post of, let's say, something. Now, they're inviting people to apply for something. That means anyone can accept. That's it. So that is the thing. So that is called general offer. Of course, that particular advertisement is not an offer, but I'm just giving you an example as to what is specific and what is general. Lapse of offer. That is when exactly an offer expires. So section 6 deals with it. Not very important, meaning the lapse of offer is important, but not section 6 as such. You don't have to remember this. So when will an offer lapse? Let's say A has told B, I am ready to sell my vehicle to you for rupees 75,000. Now, for how long will A wait until B either says yes or no. Let's see. If the offer is not accepted within specified time, this is very important. Now, what is the specified time? So specified time is nothing but reasonable time. So in contracts, or when someone makes an offer, they will usually not tell till when the other party can accept or even reject. But based on the situation, we'll have to come to some conclusion as to reasonable time. If there is a specified time already mentioned in the contract, then there is no issue at all. If A has told B in this case that I will wait for your acceptance or rejection of offer till next 1 week, then there is specified time mentioned in the offer itself. But if A has not mentioned anything of that sort, then reasonable time would be considered as the specified time. Okay, what is reasonable then? There is no fixed answer here. It depends on the nature of the offer. That's it. It is not accepted in the mode prescribed. If some offer is not accepted the way it is prescribed, then they say there is no the offer lapses. For example, let's say you send an email to someone, you tell them, I am ready to maybe render service to you. I am ready to sing in your let's say concert. You are a musician, I am a singer. I am ready to sing in your concert for X amount, but you will have to send your acceptance only through email. If you send your acceptance or agreement or contract through any other means, let's say you agree by telephone or in person, if that is the case, the offer lapses. So now A is telling B what? I am ready to sing in your concert, provided you send the reply only through email. Next. The offeree rejects it by distinct refusal to accept it. So if someone refuses to accept it, then of course it lapses. That is the obvious thing. Next. Either the offerer or the offeree dies before acceptance. Okay, that is, you can't do anything about this. So one of the parties is no longer there, then what's the point? There can't be any offer at all. If A has made an offer to sell his house to B and A dies before B has accepted and before the lapse of time, then there is no offer. The acceptor fails to fulfill condition precedent to an acceptance. Maybe A had told B, I am ready to sell my house to you for 50 lakhs. But there is one condition. The condition here is you will have to pay me only through 5 rupee coins. Now this is a condition. The condition may not make sense, but there is a condition attached to a contract. But instead B, what he does, he transfers through online mode 5 lakh rupees or 50 lakh rupees to A. Now A can very well say this is not valid acceptance. Why? Because I told you I will accept only in 5 rupee coins. How have you made the payment? Through wire transfer. No, my offer has lapsed. That's it. Then the offeree makes a counter offer. We have already seen this. A tells B 50 lakhs for my house. B says not 50, 49. Then it's rejection because B has made a counter offer. Revocation of offer by offerer. So let's see when exactly offer can be revoked or cancelled or withdrawn. An offer may be revoked by the offerer at any time before acceptance. This is very important. It's not any time, but any time before acceptance by the other party. If A is telling B, I am ready to sell my house for rupees 50 lakhs, so B has not yet accepted now. It's been 2 days since A made the offer. Someone approaches A telling him, I am ready to pay you 75 lakhs for the same house. Will you be able to sell that house to me? Now A can as well withdraw the offer which he had made to B, saying, look Mr. B, I had made the offer to you, but now I am withdrawing the offer because you have not yet accepted it. Because I am getting some other offer which is actually a better offer. There need not be any reason basically, but still, if B has not accepted so far and if A wishes to withdraw the offer, he can do that. That's the point. Next, revocation must be communicated to the offeree as it does not take effect until it is actually communicated to the offeree. Basically what they are saying is, you may revoke the offer before being accepted by the other party, but how will the other party even know that you have revoked the offer? How will you do? You will communicate to them. That communication usually should be in some formal way, written or oral or whatever it is, but the other party should get to know the offer has now been withdrawn. An offer to keep open for a specified time is not binding unless it is supported by consideration. So again, they say, if there is an offer which is considered as open offer for a specified time, even that will not be binding if there is no consideration for keeping the offer open for a specified time. That's okay. That's not a very important thing, but yeah, obvious it is. Acceptance. Let's see, what is this acceptance? It is nothing but the next logical step after proposal. You propose to someone, you offer to someone something, and if they are okay with that offer, they will simply accept it. That's all. A contract emerges from the acceptance of an offer. Acceptance is the act of assenting by the offeree to an offer. Meaning, offeree is telling the offerer, I agree, I will do this, I will not do this. So if that is the case, then there is a agreement. Offer plus proposal becomes an agreement. Offer plus acceptance becomes an agreement. Agreement plus enforceability becomes a contract. Let's look at the rules governing acceptance. Acceptance may be expressed by word, spoken or written, or implied from the conduct of the parties. Express means the party to whom the offer is made is expressing, saying, yes, of course I will do this. Or he is writing an email saying, yes, of course I agree to the terms and conditions which you have emailed to me. So therefore it is accepted through express means. Or you can also accept it through written or implied, also accept it through implied way. What is this implied way? Let's say A tells B, I will, take part in your concert as a singer, and you will have to pay me so much. Now, the other party, the musician who is actually having a concert, hasn't told anything to the singer. He has already accepted the offer, but he has not communicated. So what he does is, on the day of or rather few days before the concert, he sends air tickets to the person, that is the singer, A. Now what has he done? If he has already sent the air tickets, that means it is implied that he has agreed to the conditions or the offer of A. If he had not agreed to the offer of A, he wouldn't have sent the air tickets to the concert. So therefore, that is also valid. That is, you can accept by word spoken or written or implied from the conduct of the parties. Next. If a particular method of acceptance is prescribed, the offer must be accepted in the prescribed manner. We have already seen this. Email. Acceptance must be unqualified, seen. A counteroffer or conditional acceptance operates as rejection, seen. Acceptance must be communicated to the offerer, done. Mere silence on the part of offeree does not amount to acceptance. This is very important. Now A tells B, I am ready to, render my service as company secretary to your company. Okay, so B has a company and A is telling B, I am ready to be the CS. I am practicing company secretary anyway. You send all the documents which requires my assent, my authority. I will make sure that I will take a look into the documents. If everything is fine, I will sign. Now B says nothing. B is simply silent and only listening to A's offer. Now, after some time, A tells B, or rather A calls B and tells him, you haven't sent any of the documents of your company. I need to upload that to ROC website. Why have you not sent? Now, B can very well say that just because I was silent, it doesn't mean that I have accepted your offer. I don't like you. I don't like the way you work. That's why I didn't say anything. Just because I didn't say anything, just because I didn't say no, does it mean that I have said yes Obviously not. So that is what they are trying to say there. So if the one party to whom the offer is made, that is the offeree, does not say anything, then it is not acceptance. If the offer is one which is to be accepted by being acted upon, no communication of acceptance to the offerer is necessary unless communication is stipulated for in the offer itself. Meaning, there is some act here. By doing that, it is implied that you have already accepted. Otherwise, you wouldn't have done that. No. Now let's do the role reversal here. The musician approaches a singer, wherein he tells the singer, I am ready to pay you, let's say, 2 lakhs for this concert. You come and sing. All you have to do is just come and sing, I'll pay you 2 lakhs. The singer hasn't responded at all. But on the day of concert, they show up, he or she. Now, in such a case, there is no communication required because you have shown up, you are ready to sing. I already know that you have accepted my offer. Otherwise, why would you even come here? So that is the implied acceptance. Then, acceptance must be given within a reasonable time and before the offer lapses or is revoked. This we have already seen. No need to get into that. Contracts over telephone, same as contracts in person. So there is no difference. Intention to create legal relations. We already seen this. I don't want to get into this. All you have to do is just remember Balfour versus Balfour. As long as you remember the case or the principles behind this case, then you can easily understand what this is. Intention to create legal relations is based on Balfour versus Balfour principle, wherein the parties did not have any intention. It was simply an arrangement. That's all. Let's move on to the next important topic, which is consideration. The requirement of consideration stems from the policy of extending the arm of law to the enforcement of mutual promises of parties. Basically, what they're saying is, in a contract, there cannot be only one party who is benefiting. If there is only one party who is benefiting, what's the point of having another party? Why would the other party even enter into a contract, written, implied, whatever it is, if it is not benefiting him? So that means consideration should flow both the ways. If it is not flowing both the ways, then it cannot be considered as a valid contract. So let's see what exactly consideration means directly. Let us get into the definition that we will be able to understand it in a better manner. When at the desire of the promiser, whose desire? Promiser's desire, the promisee or any other person has done or abstained from doing, or does or abstains from doing, this is in the past, future, okay, actually present this is, and this would be future. Okay, such an act or abstinence or promise is called a consideration for the promise. That's it. So it's very simple. At whose desire it should flow? It should flow at the desire of the promiser. Let's say the musician who is arranging a concert is offering a singer an amount of rupees 2 lakhs for singing in that concert. Now, who is the promiser? The musician is the promiser. When at the desire of the promiser, promisee, singer, or any other person has done or obtained from doing, or does or abstains from doing something, let's say they sing. Musician's desire, singer is doing. What is he doing? He is singing in the concert. Such an act, in this case there is an act, there is no abstinence. Substance means not doing something, is called a consideration for the promise. Excuse me. let's do one thing. We'll stop here for now. I'll continue from the same topic tomorrow. Yeah, thank you for attending the session. Before we end the session, let me just tell you that on Ekcel Academy we just do not concentrate on the lessons part. We also have something known as CS success stories, which is a very interesting kind of a project which we are doing, wherein we are interviewing those who have passed, be it foundation or executive or final. So there are few interesting stories. Some people who don't have access to standard regular coaching, what will they even do? How can they even come to some city which is far off from their native place and stay there, spend too much of money and then prepare and pass? So in such a circumstance, it is far more easier for them to actually take up the online classes. So and there are other students who come from such humble background that you can't even imagine the situation at home, but still they have been able to study and pass, taking the help of Ekcel Academy. So if you would like to know such or watch such stories, I would suggest please go to our channel and just search for CS success stories. So it's an interview show. It will be there on our channel. Maybe there's a playlist as well. Do check it out. Anyway, see you tomorrow at 7:30. Thank you for joining, students.